Thank you, Andrea Young, for joining us today to talk about the Supreme Court arguments on Tuesday. The Supreme Court allows 20 minutes for each side, which seems awfully short. Are there lengthy legal briefs which have already been filed?
Yes, Melita, this issue has been well briefed. There are also, amicus briefs that have been filed. So yes, this has been a very well briefed issue on the particular issue that's before the Supreme Court.
It looks like there are more than 25 lawyers involved in the case, correct?
Yes, I think I was we did a moot at Kaplan Cobb. Julia Stone from Kaplan Cobb will be arguing this case for sister song plaintiffs. And I think we may have had close to that many in the moot reviewing and preparing for this very important litigation.
Well, now, are there particular things that those who are watching the court arguments should look for?
Yeah. Well, we won in Fulton County Superior Court with Judge McBurney on the constitutional issue of void ab initio, that under Georgia Supreme Court law, a law that was unconstitutional at the moment it was passed remains unconstitutional. And so that's the issue before the court. And one of the things to look for is that the justices direct their questions to that issue.
Now, if the justices have questions, does that cut into your 20 minutes?
Yes.
Wow. So how long do you anticipate it will take for the court to turn around an opinion after they hear these oral arguments? Or is there another opportunity to file briefs after the oral arguments?
I think it will really depend. Again, this is, literally the ball is in the justice's court as to whether they raise an issue that we might request another opportunity. As I said, I think we have thoroughly briefed this question of void ab initio. The concern is whether or not there's some, curveball that gets thrown by the court.
Well, we certainly wish you well, because the fate of Georgia women and all women in the Southeast, in a way, because so many other states have absolute abortion bans, rests on the shoulders of you and your attorneys.
Yes. And, on the merits, we are on very solid ground. So on the merits of, over 100 years of Georgia Supreme Court precedent, we are on solid ground. But as we know, when it comes to reproductive justice, sometimes that's not enough.